Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good morning, Madam Interpreter. I am opening court at this time, so before we call the defendant, I would like the attorneys to announce your presence for the record.
Brenda Eugene, on behalf of the State Attorney's Office.
Letitia George, on behalf of the Office of the Public Defender.
All right, Madam Interpreter, you can just go ahead and do your sound check. I'm not sure if the defendant can hear you or not.
I'm dialing to the podium.
All right, sounds good. Losta Somoza, Michael?
There is contact.
Great.
Michael Rosado Somoza.
All right.
Michael Rosado Somoza.
Okay, thank you, sir. I'm sorry. For the record, the court is appointing the public defender on all cases unless the public defender notifies the court of a conflict or some other reason they should not be appointed. In this case, it's case number 20. The clerk is going to have to give you the case number, Madam Interpreter. Sir, the court does find probable cause for the charge of battery, domestic violence, and bond is set at $500 on that count. Probable cause for attempted sex battery on a person 18 years or older, bond is set at $5,000 on that count. The court is ordering as a condition of bond that you have no contact with the victim, that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. And that you maintain a separate residence from the victim in this case. And that you have no contact with the minor child without proper supervision. Thank you, sir. I actually
Thank you.
still don't have the case number. I thought I had it. Madam Clerk, can you give the interpreter the case number?
22CF3712.
Thank you.
Thank you, Madam Interpreter. You're excused.
Thank you, Your
Raymond
Honor.
Barrett. Raymond Barrett. Mr. Barrett. Sir, in your case, the court does find probable cause for simple battery. And bond is set in this case at $500. I was not able to find probable cause for aggravated battery.
Your Honor,
Yes, ma'am.
if I may, the correct statute would be 784.041, which is,
So that information was not provided to the court. The court only received the exact same information as from yesterday. So if you are telling me what the correct statute is, are you filing something in support of that? Or are you just spontaneously telling me what you think the correct statute should be? Did you communicate with law enforcement?
no, Your Honor, I did not communicate with law enforcement.
So law enforcement said that they believed an aggravated battery occurred. What do you think actually occurred?
An aggravated battery by strangulation occurred, Your Honor.
Is that what you think? Or did you talk with the officer?
No, Your Honor, I read the affidavit, and it does mention the choking of the victim and also defendant placing his hands over the mouth of the victim.
And you come up with all of this without saying one word to the officer involved in this? Because that's nothing any different from yesterday.
That is correct, Your Honor, and as I tried
What
to...
says the defense?
Your Honor, I just ask that you stay the bond for the simple battery.
The court is finding probable cause for one count of simple battery and setting bond at $500. Ordering that the defendant have no contact with the victim in this case, possess no firearms, no weapons, and surrender any firearms or weapons in the defendant's possession to law enforcement within 24 hours of your release. Carlos Gonzalez Rivera.
Yes, ma'am.
Mr. Gonzalez Rivera,
Yes, ma'am.
in your case, sir. Oh, I got it. The court finds probable cause for count one, battery, dating violence, and bond is set in that count at $500. As to count two, aggravated assault with a motor vehicle, bond is set at $1,500. Count three, the court does not find probable cause for fleeing and attempting to elude a law enforcement officer.
Your Honor,
Yes, ma'am.
the affidavit should be before the court.
You mean a supplemental affidavit? Because all I received yesterday was
Yes, Your
the
Honor.
same as what I received today.
No, Your Honor, the
Was
supplemental
Is this
affidavit.
it? Okay, all right. The court does, based upon the supplemental report that was received this morning, at this time, find probable cause for count three, fleeing and attempting to elude a law enforcement officer, and bond be set in that count at $1,500. Further, the court is ordering that you have no contact with the victim in this case whatsoever, that you possess no firearms or no weapons, and surrender any of your possession to law enforcement within 24 hours of your release. Thank you. Syed Adil Aftab. Mr. Aftab. Sir, the court does find probable cause in your case for aggravated battery on a pregnant person. And I see there's a witness in this case. Ma'am, raise your right hand to be sworn in.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Sadia Alvi.
Spell your last name for me.
A-L-V-I.
Ms. Alvey? All right. One of the attorneys or both may have questions of you. Please make sure you speak clearly enough so that I can hear any of your responses. Thank you.
Good morning, ma'am. How do you know the defendant?
He is my significant other. Can I have a private attorney that's supposed to zoom in.
You have a private attorney that's supposed to zoom in?
Yes.
All right, can we confirm, is he representing the defendant?
Correct.
Okay, can we confirm whether the private attorney, how do we do that? Here? Okay. Leave it to call. Osceola, interpreter, voicemail, interpreter, Osceola, Osceola. Which one? This one?
Welcome to an Econo meeting. You are entering the meeting now.
Ma'am,
Good morning,
what is the attorney's name?
Yes, this is her, Rachel Starr.
Rachel.
Okay,
Shaw.
good morning. Can you please just spell your last name for the record?
Me, Rachel Shaw, SHAW.
All right, Ms. Shaw. Ms. Shaw, have you filed a notice of appearance in this case?
Yes, Judge, this morning.
All right, so you are officially representing Mr. Aftab?
Yes, Judge.
Okay. No questions have been asked yet other than for the witness to identify herself. And if the state has additional questions, the state may inquire at this time.
Yes, Judge. May I question the witness?
Well, the state was in the process of
Oh,
questioning the witness, but she has not questioned the witness. I'm going to let the state finish, and then you can question the witness.
thank you, Judge.
Ma'am, I believe you said that the defendant is your significant other.
Correct.
Do you live together?
We are currently separated. We do not live together.
Okay. Has something like this happened before?
No,
Were drugs or alcohol involved in this incident?
no.
While this case is pending, would you like to have contact with him?
I do want contact with him.
I have no further questions, Your Honor.
Ms. Shaw, you may ask questions.
Thank you. Miss Alvey, are you in fear of Mr. Aftab?
Yes,
I asked if you're in fear of him?
oh, and I'm sorry, I didn't, no, I am absolutely not in fear of him.
Okay. Do you wish to have contact with him?
I do wish to have contact with him.
And would you feel comfortable calling the police if you felt threatened?
I will feel comfortable, yes.
And do you understand that the judge at initial appearance can order no hostile contact, which means that you'd be allowed to communicate and have contact with each other as long as it's non-threatening or violent contact?
I understand.
And you're currently pregnant with his child?
Correct.
I have no further questions.
Thank you, Ms. Shaw. Anything further?
Nothing from the
All
state.
right. Ma'am, based upon what I read in this probable cause affidavit, I was very concerned about allowing contact. And I'm not sure that you understand just how south these kinds of incidents can go. And I hope that your answer to the question, would you feel comfortable calling the police if you needed to? I hope you will do that. Do you understand, ma'am?
I do understand.
Because that's the only way that I'm gonna allow contact. Do you understand?
Absolutely, I understand.
All right, I'm going to order a bond of $1,000. I'll order no hostile contact with the victim. Possess no firearms, possess no weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you.
Thank you, Judge.
Onyx Omar Medina Galarza. All right, Mr. Galarza, the court finds probable cause in your case for false imprisonment, count 1, tampering with the witness to hinder communications, count 2, and battery domestic violence, count 3. And I do see that we do have a witness in this case as well.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Dominique Brown.
Ma'am, I'm going to need you to speak up a little louder, and I also need you to spell your last name for me.
Dominique Brown, my last name Brown, Brown.
All right. One or more of the attorneys may have questions for you, ma'am.
Okay,
Good morning, Ms. Brown.
good morning.
How do you know the defendant?
My significant other.
Do you live together?
No, we do not.
Has something like this happened before?
No.
Were drugs and alcohol involved in this incident?
Alcohol, yes.
While this case is pending, would you like to have contact with him?
No hostile contact.
Thank you. I have no further questions, Your Honor.
So, ma'am, unfortunately, your last response, I could not hear it. And,
No hostile contact.
all right, so I just need clarification. I make a decision on what type of contact you're going to have. The state asked if you would like to have contact with Mr. Galarza. Can you just answer whether you would like to have contact with him or not?
Yes, contact.
You would, okay, thank you. Anything further?
Oh, would I be able to just state that the night that had happened, I don't believe the first charge of the false imprisonment is correct. I didn't leave a statement, but from what they seen, I did have myself in the way the layout of the house is.
The problem is, ma'am, I'm not convicting him of false imprisonment.
I just wanted to let you know that.
Hold on a minute, I'm just determining whether there's probable cause for the charge.
Okay.
And there will be time in future court hearings for the attorneys to determine whether or not there's sufficient evidence for the charge, for conviction for the charge. But in terms of probable cause, I do believe there's probable cause for that charge.
Okay.
Nevertheless, I have heard your testimony and I understand that you want to have contact, so I'm going to allow that. Bond is set at $1,500 in count one, $500 in count two, $500 in count three. The court will order no hostile contact with the victim. Since this defendant does qualify for PTR, the defendant may participate in PTR or pay or post the bond. The conditions are the same whether the defendant participates in PTR or posts the bond. The defendant must surrender any firearms or weapons in his possession to law enforcement within 24 hours of his release and possess no firearms or weapons while out on bond or PTR. Thank you, and thank you, ma'am.
Thank you.
Michon Fitzgerald Harrington. Mr. Harrington, sir, the court does find probable cause in your case for aggravated assault, dating violence, and set a bond in your case at $1,500. I am ordering that you have no contact whatsoever with the victim in this case, and that you maintain a separate residence from the victim in this case, that you possess no weapons or firearms as a condition of your bond. Also, sir, you are allowed a one-time visit in the presence of law enforcement to recover any personal belongings or effects.
Okay.
Surrender any firearms or weapons within 24 hours of release. Zaquante Lorraine.
Yes, ma'am.
Mr. Lorraine, the court finds probable cause of her aggravated battery with a motor vehicle, and bond is set in that case at $1,500, as well as count two, aggravated battery with great bodily harm with a weapon. In that case, bond is set at $1,500.
I don't understand. Can you?
Sir, I'm sorry, I can't hear you.
I'm saying that I don't understand because I was just told not to say anything. I'm trying to find out, how did you find probable cause? I tried to call the police too. I see.
Well, the reason why the lawyer is telling you to stop talking is because I am appointing the lawyer to represent you. I appoint the public defender at all IAs, and the public defender is concerned that you may say something that will harm your case. So that's why she didn't want you to say anything. The initial appearance is a very brief proceeding. It's not a proceeding where normally there's a lot of evidence or testimony. Sometimes there is testimony from a witness who can help the court determine what the conditions of a bond might be, but there's no testimony that helps the court determine guilt or innocence in your case. So I am ordering the bonds as I stated, and I am ordering that you have no contact with the victim in this case, that you possess no firearms or no weapons, and surrender any of your possession to law enforcement within 24 hours of your release. You have an out on bond case, which I will be taking no action in the out on bond case. No return. Yes, ma'am. No return. One-time visit in the presence of law enforcement for personal effects. Terrence O'Neill.
Good morning, Judge.
Good morning, Mr. O'Neill. In your case, sir, the court finds probable cause for aggravated battery with great bodily harm, and I am setting a bond in that count at $2,500. False imprisonment bond is set at $5,000, and tampering with a witness to hinder communication bond stays at $250. In this case, I am ordering that you have no contact with the victim whatsoever, that you not return to the location, and that you surrender any firearms or weapons to law enforcement within 24 hours of your release, and possess no firearms or weapons as a condition of the bond. Jennifer Principe. All right.
I will waive the appearance, Your Honor.
As to Ms. Principe, the court does find probable cause to the charge of battery, domestic violence. Bond is set at $500. No contact, no return, no weapons or firearms, and surrender within 24 hours of release. Natalie Sparrow.
Your Honor, she has a second case for Jennifer.
Oh, I'm sorry. 2 cases? Did I miss one?
I think it's the drug.
Yep, sure did. Okay. This. All right, the court also finds probable cause in the second case. Count 1, possession of a controlled substance, bond is stated at $1,000. Count 2, bond stated at $150, and count 3, $100. Possess no narcotics, possess and consume no narcotics or illegal drugs as a condition of bond, and random drug testing. Natalie Sparrow.
Yes.
Ms. Sparrow, the court finds probable cause in your case of burglary of a dwelling with a assault or battery with a firearm. Bond is set in that case at $25,000.
Your Honor,
Yes, ma'am.
burglary with an assault or battery therein is a first-degree felony punishable by life. At this time, the state would ask defendant be held no bond.
Defense.
Your Honor, I'd ask that based on her history and the facts of this case, you use your discretion to set bond.
The court, based on this case, the court's going to set bond at $25,000. As to count 1, As to count 2, bond is set at $100. The court is ordering as a condition of bond that the defendant have no contact with the victim in this case, that the defendant possess no firearms, no weapons as a condition of bond, and surrender any firearms or weapons to law enforcement within 24 hours of release. Further, the court is ordering the defendant not to return to the location where this incident occurred. Looking at the defendant's history, she did not qualify for PTR because of the nature of the charge, but her risk assessment results were low. And she doesn't appear to have major criminal history or any criminal history. So I don't know how long she would have to sit in jail before a bond hearing would occur. So the court, based on the nature of the charges, is concerned, but also the defendant can have a bond in this case. Ma'am, your excuse. Mario Jose Torres Santiago. Mr. Torres Santiago, in your case, I find probable cause for count 1, tampering with the witness. Bond is set at $1,000. Additionally, count 2, battery, dating, violence. Bond is set at $500, and count 3, bond is set at $100. The court is ordering that you have no contact with the victim in this case, that you possess no weapons, you possess no firearms, and surrender any in your possession to law enforcement. You will also qualify for PTR. So, sir, I am going to order as an alternative that you be released PTR. The conditions remain the same, whether you post the bond or participate in the PTR program. I did say everything. Surrender any firearms or weapons within 24 hours of release if I didn't announce that. Sir, you're excused. Thank you. Bryson J. Bridges. Mr. Bridges, I am finding probable cause in your case for the charge of battery, domestic violence, and I see that we do have a witness, victim present. At this time, let's swear that person in.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record and spell your last name.
Brittany Mays, Mayes.
All right, Ms. Mays, either one or both of the attorneys may have questions of you regarding this case. So make sure that you answer the questions as clearly as you possibly can. Thank you.
Good morning, Ms. Mays. How do you know the defendant?
We've been married almost a year. He's my husband.
You live together.
Yes, ma'am.
Has something like this happened before?
Yes, ma'am.
Are you afraid of him?
Yes, ma'am.
While this case is pending, do you want to have contact with him?
No, ma'am.
I have no further questions, Your Honor.
Defense, you have any questions?
No questions, Your Honor.
All right, sir, I am ordering a bond in the amount of $500, ordering you to have no contact whatsoever with the victim, not to return to the location where this incident occurred. However, you do have the authority to return once in the presence of law enforcement to retrieve any personal belongings. You must possess no firearms or weapons as a condition of your bond, and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you. Thank you, sir.
We have a private. Your Honor, I'd ask that we not be appointed. He has a private attorney instead.
All right, the court will order that the public defender is not appointed in this case.
Twice.
Jerry Lee Bryant. Mr. Bryant, the court finds probable cause in your case for count 1, battery, dating, violence, and bond is set at $500. And count 2, criminal mischief, bond is set at $150. No witnesses. The court is ordering in your case that you have no contact with the victim whatsoever, that you possess no firearms or weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of release, that you not return to the location where this incident occurred with the exception of a one-time visit in the presence of law enforcement to recover personal belongings. Thank you. Thank you, sir. Mr. Day, Scott Eugene? Mr. Day? The court does find probable cause in your case for battery, and bond is set at $500. There's a witness, so we'll swear the witness in.
Raise your right hand, please. Do you swear or affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Jennifer Jakes, Jacquees.
All right, Ms. Jakes, either one or both of the attorneys will have questions for you. Please make sure you answer clearly so that I can hear you, okay?
Yes, ma'am.
Good morning, ma'am. How do you know the defendant?
Oh, he's my significant other.
Do you live together?
Yes, we do.
While this case is pending, would you like to continue having contact with him?
Yes, I would.
Has something like this happened before?
Yes, it has.
Can you tell me the last incident?
It's a while ago.
Okay. Were drugs or alcohol involved in this incident?
No.
I have no further questions, Your Honor.
No questions from defense.
Whatever happened was bad enough that the dog got involved, and according to this, the dog bit him. Sounded like you needed protection.
I just have a crazy dog. That's how the dog is.
Well, I think the dog was the hero of this incident.
It's not the case.
I'm really concerned. I didn't hear you say that you're not afraid of him.
I'm not afraid at all of him.
You're not?
No, I'm not.
Who does the dog belong to?
Both of us had him.
Well, you know, I'm kind of concerned about the dog.
I mean, the dog went to bite me too last night. That's why.
Well, I'm not concerned about that. I'm concerned about any hostile conduct towards the dog.
No, the dog.
Not
actually
not
went
you,
after both
ma'am.
of us.
Not you.
Oh, okay.
It almost seems like if someone does, or something like a dog does a good deed and protects you, that's who you should be concerned about protecting, not the person who harmed you. And I'm just hearing you in denial, and I'm just worried about what's going to happen to that dog if I let him have contact with you. And you don't seem to be concerned about it, but I'm concerned about it. The poor animal was trying to help you. I'm going to order no contact whatsoever with the victim, and no contact with the dog that is a part of the household. Are there any other pets?
No, ma'am.
Your Honor, would you be willing to just do a maintain separate residences, but allow the contact, being that she's not afraid?
How do I protect the dog?
No, I'm saying they can't live together, but they could have contact, telephone contact. He can't return to the home, being that she wants contact and he would like contact as well. So if they live separately, she stays with the dog.
That doesn't matter. He could still come over there and do something to that dog.
He didn't do anything to the
That's
dog.
why I said no. He's had the dog for 8 years. He's had the dog for 8 years, Your Honor.
The dog bit me too. The dog, it's the dog.
Yeah, well, you know, I'm sorry, but I'm just concerned about the dog. I mean, it's in the police report the dog came to your rescue. The dog was trying to help you. And I haven't heard anyone be concerned about the dog this morning except for me.
Your Honor, that's why I said if we do the maintain separate residence, he's not allowed to return to the home where the dog is, but they can have telephone contact or somewhere else other than the house, the no hostile contact outside of the home. So they live apart. She can stay at the house with the dog and just keep the no contact with the dog as well, and just have telephone contact. I think that would protect the dog and eliminate your concerns, Your Honor.
Okay. Because the dog can't call and make a report if the dog gets kicked in the face because of what happened.
Correct, Your Honor.
And that is my concern. If people are going to have pets, then people should protect the pets. And I am just very concerned about what's going to happen to the pet as a result of what happened in this case.
The incident with the dog was over food that the dog wanted. The dog was going after both of us. It was not
Ma'am,
to protect me.
Ma'am, listen. I am just going by what I read in the police report.
And I did not.
And ma'am,
Yes.
what I read seemed to me that you and your husband were in an altercation and the dog bit him while he was attacking you. That's what the police report said. I haven't heard you say, Your Honor, I will protect my dog. I will make sure nothing bad happens to the dog. I haven't heard you say that. So I'm going to keep my order the way it is. No contact. Maintain separate residences. I'll do both.
The dog, can I please, I do care about my dog.
I'm glad to hear that.
Nothing will happen to my dog.
Oh, well, after I mentioned it and told you that that was something I was concerned about, you finally brought it up. That would have been the first thing I would have said. But ma'am, my order is my order. You all can take it to the next judge. But I'm not going to change this order because I read that the dog came to your rescue and attacked him while he was attacking you. And I'm just really concerned as to what's going to happen to that dog. I'm not even sure the dog should still live in the house anymore. But I can't enter an order making you take the dog to go live somewhere else for his protection. So I'm just ordering that he has no contact with you. You maintain separate residences. He possessed no firearms or weapons as a condition of bond, and surrender any firearms or weapons to law enforcement within 24 hours of release. And maybe you all can figure out how that dog can be protected in the future. The dog shouldn't have had to be involved in that incident. At no return, with the exception of a one-time visit with law enforcement to recover personal belongings. Alexis Dublin. Mr. Dublin, the court does find probable cause in your case for the charge of battery. I'll set bond at $500, order you have no contact with the victim in this case, not return to the location where this incident occurred, with the exception of a one-time visit to recover personal belongings. You do qualify for PTR, so if you, I'm actually going to allow you to participate in PTR or post the bond. The conditions will remain the same whether you participate in PTR or post your bond. No weapons, surrender any weapons to law enforcement, no weapons, no firearms. Surrender any weapons or firearms within 24 hours of release. Thank you, sir. Joseph Angelo Esposito. Mr. Esposito? Is that who you are? All right. I do find probable cause in your case for battery, dating violence. I see we do have a witness present, so we're going to swear the witness in.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record and spell your last name.
Maria Hurtado, Hurtado.
All right, Ms. Hurtado, you're going to be asked questions by one or both of the attorneys. Please make sure that you answer clearly enough so that I can hear your responses. Thank you.
Good morning, ma'am. How do you know the defendant?
He is my significant other.
Do you live together?
Yes,
Has something like this happened before?
yes.
Can you tell me the last incident?
What is it?
The last incident, the last time it happened?
September last year.
Thank you. Were drugs or alcohol involved in this incident?
Yes.
While this case is pending, would you like to have contact with him?
All I want is my apartment key. Even though he lives with me, he moved it into my apartment with my roommate. So all I want is a key. I don't want another officer coming into my house and moving the stuff, walking in my room.
Okay. I apologize. I don't really know how to interpret that as to whether or not you want.
If I say no contact, there's gonna be a police officer coming into my apartment, going into my house with him through my stuff as well.
No, ma'am. The officer would only return with him the one time so he could get his things.
How long does
His
that not
things.
contact?
I'm sorry?
How long does that not contact?
That lasts until the next court
No
date,
contact.
until, so no contact?
Yes.
Okay. And one other question, are you afraid of him?
Only when he drinks.
Okay. I have no further questions, Your Honor.
Any questions?
No questions from defense.
All right, the court does find probable cause. Bond is set at $500. Since the defendant actually does qualify for PTR, the court will allow bond or PTR with the following conditions. The defendant consume or possess no alcoholic beverages and frequent no establishments that serve alcohol primarily, subject himself to random urinalysis for alcohol testing, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release, have no contact with the victim with the exception of a one-time visit in the presence of law enforcement to retrieve any personal belongings. Thank you. Thank you, ma'am. Xavier Miriz McClooney. Xavier McClooney, Mr. McClooney. Court finds probable cause in your case for battery domestic violence, and I think there's a witness in this case.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record and spell your last name.
Jita Holly, last name Holly, Holley.
Thank you, Ms. Holly. The attorneys, one or both, may have questions of you. Please answer clearly enough so that I can hear your responses. Thank you.
Good morning, Ms. Holly. How do you know the defendant?
He's my significant other.
Do you live together?
Yes.
Has something like this happened before?
No, never.
Were drugs or alcohol involved in this incident?
No, ma'am.
Are you afraid of him?
No, ma'am.
While this case is pending, would you like to have contact with him?
Yes.
I have no further questions, Your Honor.
Any questions from the defense?
No questions, Your Honor.
All right, ma'am, sir, the court finds probable cause and sets bond at $500, orders no hostile contact with the victim, orders that the defendant possess no weapons or firearms as a condition of bond, and surrender any in his possession to law enforcement within 24 hours of release. Thank you. Thank you, ma'am. Larry Shepard. Mr. Shepard. Mr. Shepard. Sir, the court finds probable cause in your case for battery, dating violence, and bond is set at $500. And I'm ordering you to have no contact with the victim in this case, ordering that you possess no firearms or weapons. Oh, actually, you also qualify for PTR, so bond is $500 or PTR, and with the conditions being the same. No contact with the victim, possess no firearms or weapons, and surrender any firearms or weapons within 24 hours of release. Do not return to the residence where this occurred, with the exception of a one-time visit with law enforcement to recover personal effects. Thank you, sir. Zarian West Walters. Mr. Walters, the court finds probable cause in your case for charge of battery, domestic violence, and orders as follows: that you have no contact with the victim, possess no firearms or weapons as a condition of bond, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Further, you must not return to the location where this incident occurred, and with the exception of a one-time visit with law enforcement to recover any personal belongings. Bond is $500. Marcus Maurice Brown.
He's in the hospital, Your Honor?
Hospital, we'll reset this. Sarah Marie No. Ma'am, you were picked up on an out-of-county warrant from Seminole County. Bond is staying at $2,000 in that case. Thank you, ma'am. Lisa Marie Santana Torres. We don't get sheets for.
Wait, who is, no.
Lisa Santana Torres. All right, you were picked up on an out-of-county warrant. Seminole County. Bond stays set at no bond in this case. Thank you, ma'am. Robert Kevin Buckley. Mr. Buckley? Mr. Buckley? Is this Buckley?
Yes, ma'am.
Okay. Sir, you're charged with violation of your probation by failing to attend and successfully complete a batterer's intervention program.
Yes.
Hold on a moment, sir. And violation of your probation by failing to pay $20 per month towards costs of supervision. Bond will stay set at no bond in your violation of probation case. I have appointed the public defender to represent you. Thank you, sir. You're excused. Jonathan Guivas Colon.
He was aware of what happened.
Jonathan Guivas Colon.
Your Honor.
Yes, ma'am.
There's actually no.
Okay. Mm-hmm.
You already did her, but she wasn't up here when you went through her paperwork.
Oh, she wasn't?
No.
Okay. Well, there was someone there.
Yep, it was Torres
Okay.
was standing.
So was Torres there when I did Torres?
Yes.
So the same. Yeah, I thought she looked the same. I'll redo Miss. I thought, she looks the same as the last lady.
Yeah.
Ms. No, at Miss Sarah No. All right. You were picked up, Miss No, on an out-of-county warrant, and bond, and this is Seminole County, and bond was set at $2,000 and will stay at $2,000 in that case.
Okay.
Thank you. Jonathan Colon.
Yes.
All right, you're here based on a violation of your probation as follows: Condition A, failing to report to the probation officer as directed on 2/14/22. And condition L or I, failing to pay the state of Florida $20 per month towards cost of supervision. Bond stays set at no bond in your violation of probation case.
Okay.
Brittany Rainey. Ms. Rainey, ma'am, you're picked up for violating your probation of a special condition by having contact, direct or indirect, with the victim or the victim's family during the supervision period. And in this case, bond will stay set at no bond. Thank you, ma'am. Juan Robinson. Sir, you were picked up for violation of your probation. Condition A, by failing to report to the probation office as directed on 1/5/22. Condition D, by making yourself unavailable for supervision without first procuring the consent of your probation officer. Bond will stay set at no bond in your violation of probation case, sir. Raymond Cesar Salcedo.
Yes, ma'am.
Mr. Salcedo, you violated your drug probation as follows. Violation of a condition E, failing to live without violating the law and by being arrested for a criminal offense of driving while your license was suspended or revoked with knowledge, actually suspended or lesser included offense on 3/24/22. And violation of condition Q, by failing to participate in a specialized drug treatment program, either inpatient or outpatient, as recommended by the treatment provider. Bond will stay at no bond in that case. Jennifer Lynn Witt. Ms. Witt, you actually have two cases. As to your first case, violation of probation. Condition A, by failing to report to the probation officer as directed on 11/9/2021. And changing residence or absconding, which is a violation of conditions B and D, by changing your residence without first procuring the consent of the probation officer. And failure to complete community service hours by the court-ordered date, which is a condition of your probation to complete 20 hours at a rate of 8 hours per month. And failing to successfully complete outpatient treatment by failing to successfully complete or remain in a drug or alcohol treatment program until the provider determined that treatment was no longer necessary. And bond will stay at no bond in that case. You also, the court also finds probable cause for possession of cocaine, and bond is stayed at $1,000. In that case, you're ordered as a condition of that bond to possess or consume no illegal narcotics and subject yourself to random drug testing as a condition of bond.
I'm sorry, Your Honor. For Ms. Witt, she also has another case, a VOP on view for the same case number, but one was a warrant and the officer also did an on view. I'm guessing because of the possession of cocaine charge.
Okay, and yes, you're right. The court is also ordering a no bond status on the violation of probation on view based on the new law violation of possession of cocaine.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Readdressing from this morning, Randy Chappelle. This is a motion for release on recognizance, automatic release. The court doesn't recall whether the state objected to that one or not.
There was no objection, Your Honor.
All right, then this motion is granted. All right. Recalling Natalie Crystal Sparrow, also from this morning. Ma'am, the court has reconsidered the court's bond that I ordered this morning in your case and reviewed the paperwork and reconsidered the state's motion. And the state had moved the court to leave bond set at no bond. And after reflection and reviewing the paperwork, the court's going to grant the state's motion and leave the bond set at no bond. And I know you probably want to know the reasons why. And after reviewing the paperwork, the court had noted that there was, in fact, another victim present. It was not readily apparent when I reviewed the paperwork earlier. There were actually 2 victims, and it was a situation where it doesn't appear that it was a home where you ever previously resided. The court was recalls there may be a potential pregnancy that was alluded to, that maybe you're pregnant and maybe perhaps the victim might be the father. And so the court was under the potentially not necessarily correct impression that this may have been a home where you previously resided or was residing. But it appears that it may have been his home with another person. This case could have been a situation that quickly got out of control and may have resulted in a tragic outcome. So the court's going to amend the court's original order, granting a bond and leaving the bond set at no bond as to the charge of burglary of a dwelling with a battery and a firearm. I am going to leave the bond of $100 on the criminal mischief. I'm still ordering no contact with the victim, but also no contact with any residents of that home. State, do you have any information as to whether the second victim resides at that home, or should I just order no contact with her by name?
If you could do it by name, Your Honor, I believe she is the wife of the listed victim.
Okay, staff, but I didn't realize I needed to tell you also. 2022 CF 3553AO, and I want to put the female who was the wife who was present. I want to put her name in that order, no contact with her. Additionally, no possession of any firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release, and did not return to the location where this occurred. Is there a name in the I don't recall there being a name. There may be.
I'm looking at it now, Your Honor. I'm looking at the affidavit.
I could order no contact with the victim or the victim's wife.
Yes, Your Honor, I think that would be best.
So no contact with the victim or the victim's wife. Now, ma'am, your attorney can inform you that they can still file a motion in the future and ask the judge to address setting a bond in your case.
Thank you, Your Honor.
Oh, I apologize, Your Honor. The name is listed. It is Ramonique Murphy.
All right, no contact with the victim, no contact with the victim's wife, Ramonique Murphy. It seems to me that she should have also been listed as a victim since she was present.
Hi, good afternoon.
Good afternoon. All right, let's see, how am I gonna do this? Okay, I'm gonna do it like this. Johnny Ray McCauley.
Yes, Your Honor.
All right, court finds probable cause in your case for trespass on property after a warning.
And Your Honor, the offer from the state is an adjudication, sorry, here, Mr. McCall. Adjudication of guilt, credit time served, no return to 1501 North Alafaya Trail. Mr. McCall would like to accept and enter a plea of no contest.
Yes, ma'am.
Yes, Your Honor.
Mr. McCauley, is this your signature at the bottom of this plea form, sir?
Yes, Your Honor.
Did you read this document in its entirety before you signed it? Did you read it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine at this time?
No, Your Honor.
Do you understand that by pleading no contest, you're giving up all the rights on the plea form?
Yes, Your Honor.
Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, Your Honor.
There's a sufficient factual basis in your case. You're alert, you're intelligent. I'll adjudicate you guilty. Order credit for time served
It's 2 days.
in the amount of 2 days in order that you not return to 1501 North Alafaya Trail, as well as that you pay mandatory court costs. All court costs must be paid within 180 days. If you're unable to pay within that time, you must request an extension from the clerk of court. I am ordering your release as to this charge, sir. Any questions?
No, Your Honor.
You have
Thanks.
the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit for your paperwork. Thank you.
He's done. You're done.
Jonathan Bellamy.
Oh, I'm sorry, Bellamy is, refused.
Bellamy will be reset. James Purnell Bynes Jr.
Yes.
Sir, the court finds probable cause for the offense of trespassing in a structure or a conveyance.
Your Honor, and the offer from the state is an adjudication of guilt, credit time served, no return to 5858 International Drive, and court costs that Mr. Bynes would like to accept and enter a plea of no contest.
All right, that's fine.
Here you go.
Is this your signature at the bottom of this plea form, Mr. Bynes?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it?
Yes.
Do you understand that by entering your plea of no contest, you're giving up the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, there's a sufficient factual basis. You're alert, you're intelligent. I will adjudicate you guilty, order credit for time served
He has 1 day.
in the amount of 1 day, in order that you not return to 5858 International Drive. You must also pay mandatory court costs within 180 days. You must request an extension of time from the clerk of courts if you're unable to make the full payment as ordered. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Do you have any questions?
No, ma'am.
Thank you. You may exit.
You're welcome.
Is this next? Pedro Rivera. Does it require an interpreter? Does it require an interpreter? Okay, I don't know what's going on. What did you say? T-O-T?
He was turned over to Osceola.
Okay, I was trying to figure out what the tot was. I mean, tater tot, little tot. Okay, so is this not Pedro Rivera? No, ma'am. Okay, all right, that one's, he's,
I don't know which one we're doing. Are we on arraignment?
Pedro Rivera arraignment.
is Pedro Rivera coming back from Osceola or?
It may be a while, it's not gonna be today, no.
I will waive.
Oh, it won't be today. You will waive?
Yes, Your Honor.
So it's an arraignment. You're waiving formal arraignment?
Yes, Your Honor, if you,
Appoint the public defender?
yes, we'll waive and enter a plea of not guilty.
So based on the defendant being incarcerated, I'll find that the defendant qualifies for the public defender, appoint the public defender, and reschedule the case in Division 63 for pretrial conference.
Will be May 12th at 1 o'clock in courtroom 10B.
Thank you. All right, y'all know these initials and acronyms, I don't know them. Somebody's gonna have to give me a list of all the initials. T-O-T. Like, okay, what kind of tot are we talking here? William Leroy. William Leroy. Mr. Leroy. The court does find probable cause in your case for trespass on property after warning.
And, Your Honor, the offer is an adjudication of guilt, credit time served, and no return to 2935 West Oak Ridge Road in court cost, and Mr. Leroy would like to accept and enter a plea of no contest.
All right, that's acceptable.
And he has 2 days, Your Honor.
Thank you, ma'am. Mr. Leroy, is this your signature on this document being handed to me? Yes. This is a plea form. Did you read it before you signed it? Yep. Are you under the influence of any alcohol or drugs or medicine? No. Do you understand that by signing this plea form and entering this plea, you're giving up the rights on this document? Yep. Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? Yep. So there is a sufficient factual basis. You're alert, you're intelligent. I will adjudicate you guilty, order 2 days in jail with credit for the 2 days you served. Order you not to return to 2935 West Oak Ridge Road, and order you to pay court costs within 180 days of your release. I'm ordering your release as to this case. If you cannot make the full payment in 180 days, you must request an extension of time from the clerk of courts. Do you have any questions? No. You have the right to appeal the sentence. If you wish to appeal, then you must do so in writing within 30 days of today's date, and you may exit, sir. Thank you.
Yep.
Gianna Elizabeth Roish. Thank you. You can exit. Ms. Roche? Ma'am, the court finds probable cause in your case for trespass in a structure or a conveyance.
Your Honor, the offer is a withhold of adjudication, credit time served, no return to 2912 West Arlington Street, and court cost. And Ms. Roche would like to accept and enter a plea of no contest.
All right, Ms. Roche?
I don't know how to say it, Your Honor. I'm sorry.
Okay, I'm gonna go with Roche.
Roche.
Okay, that's what I thought. Ms. Roche, ma'am, is this your signature here at the bottom of this plea form? And did you speak up for me? Yes? This is your, did you read the plea form in its entirety before you signed it?
Yes.
You understand that by entering a plea of no contest, you're giving up the rights on the plea form?
Yes.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
If there is a sufficient factual basis, you're alert, you're intelligent. Ma'am, I'll withhold adjudication of guilt, credit
2 days.
Order 2 days in jail, credit for the 2 days you served, order you to not return to 2912 West Arlington Street. Further, you must pay mandatory court costs within 180 days of your release, which I am releasing you as to this charge. Further, if you are not able to make a full payment within 180 days, you must request an extension from the clerk of courts. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, ma'am. You can exit now. Albert Antonio Williams. Mr. Williams, the court finds probable cause in your case for the charge of trespass on a structure or conveyance.
In your honor, the offer from the state is an adjudication of guilt, credit time served, no return to 2912 West Arlington Street. And Mr. Williams would like to accept and enter a plea of no contest.
Mr. Williams, is this your signature here, sir?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it? You understand that by entering the plea of no contest, you're giving up the rights on this form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No, ma'am.
And do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen? Sir, there is a sufficient factual basis. You're alert, you're intelligent. I'll adjudicate you guilty. Order 2 days
2 days.
with credit for 2 days' time served and order you not to return to 2912 West Arlington Street. Further, you must pay mandatory court costs within 180 days. If you can't pay it all within that time, you must request an extension from the clerk of courts. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
And you're taking no action on the auto bond?
Oh, yes, ma'am. No action on the out on bond case. And Josie Oliver Campbell, you were picked up for failure to appear. Bonds, they set at $2,000 for your failure to appear, sir.
In your honor, the offer from the state is an adjudication of guilt, credit time served, no return to 624 Lexington Avenue. And Mr. Campbell would like to accept and enter a plea of no contest.
And he has 5 days credit time served, Your Honor.
Okay. I keep putting the case number in and it keeps coming up, no match found. I'll try it one more time. 2019 MM 848280. Well, you got the charm. There it is. Enough. I don't have a factual basis on this case. Can either the state or the defense provide me with a factual basis?
Yes, Your Honor. On October 17th of 2019, in Orange County, Florida, Mr. Campbell did willfully enter and remain in the property of 633 Lake Dot Circle in Orlando, Florida, which was the Salvation Army, and the owner did instruct him to leave, at which point he refused, Your Honor.
This is Mr. Campbell?
Yes, Your Honor.
So the address that you announced earlier in the plea is 624 Lexington Avenue.
Oh, let me see. The address, oh, I see.
Is that his address?
Sorry, it is, because both addresses are listed in the report, Your Honor. So it states that they responded to William Booth Tower in response to the trespass, where he was standing in the parking lot of the Salvation Army. And the Salvation Army instructed, they kept telling him to leave and having issues with him all morning and wanted him trespassed, at which point he continued to refuse to leave the parking lot of the Salvation Army.
So in the information, the address is 633 Lake Dot Circle. Where did you get the 624 Lexington Avenue address?
The 624 is the address for the Salvation Army that I was given by the state. And when you look in the arrest affidavit, it lists both addresses, Your Honor. It appears the officer responded, it says to William Booth Tower in reference to a trespass. And upon arrival,
All right, do you want me to just put both addresses in the do not return order?
State, is that what you?
Yeah, if you just list, yes, please, Your Honor, both addresses.
Mr. Campbell, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this plea form before you signed it?
Yes, Your Honor.
Are you under the influence of any alcohol or drugs and medicine this afternoon? Does the medicine in any way affect your ability to understand what you read on this plea form or what you and I are discussing right now? Is that a no?
No, Your Honor.
Okay. Do you understand that you're giving up the rights on this plea form by entering your no contest plea?
Yes, Your Honor.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am, Your Honor.
All right, there's a sufficient factual basis in your case and you are alert and intelligent. I'll adjudicate you guilty. Time served.
Yes, 5 days.
Order 5 days with credit for 5 days. Time served. Order you not to return to either 624 Lexington Avenue or 633 Lake Dot Circle in Orlando. You must pay mandatory court costs
Yes, Your Honor.
within 180 days of your release or request an extension of time if you're unable to pay it within that time frame. I am ordering your release as to this charge. Do you have any questions, Mr. Campbell?
No, ma'am, Your Honor.
All right, you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit. Thank you.
Yes, ma'am.
Donald Ayers. Mr. Ayers, the court finds probable cause for possession of an alcoholic beverage or open container of alcoholic beverage.
And Your Honor, the offer from the state is a withhold of adjudication, credit time served, and court costs. And Mr. Ayers would like to accept and enter a plea of no contest. Thank you.
Mr. Ayers, is this your signature? Served
Yes, 2 days.
in the amount of 2 days, and I'll order mandatory court costs, which must be paid within 180 days of your release. I am.
He did bond? They said he had bond.
I didn't hear what you said.
Apparently he bonded.
Oh, he bonded.
Bonded, okay.
Even better.
Okay, so apparently he bonded. Okay, we're gonna go with that. Tyler Vance finds probable cause for the